Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Samuel Nektalo, decided May 16, 2024. Singhas, J. Defendant claims that the prosecution failed to meet its burden in establishing that law enforcement had probable cause to stop the vehicle in which he was a passenger. We agree. 1. In 2018, NYPD Detective Gregory Fortunato and his partner observed a car with excessively tinted windows traveling on a public road. Detective Fortunato pulled the car over and, upon approaching, observed marijuana in plain view. The officers arrested and searched defendant, recovering 2 bags containing cocaine from him. Defendant moved to suppress the drugs, arguing, among other things, that the officers lacked probable cause to stop the vehicle on the basis of a traffic violation. At the suppression hearing, Detective Fortunato testified that he pulled the vehicle over because he observed that it was traveling with excessively tinted windows, but failed to elaborate further. Criminal court denied defendant's suppression motion, finding, as relevant here, that Detective Fortunato properly stopped the vehicle in which defendant was a passenger because the car apparently violated Vehicle and Traffic Law, Section 375, 12A, B, 2, for having excessively tinted windows. Defendant pleaded guilty to criminal possession of a controlled substance in the 7th degree. The appellate term affirmed, with 1 justice dissenting. The court held that Detective Fortunato's testimony sufficiently established that the detective had probable cause to lawfully stop the vehicle due to an apparent violation of Vehicle and Traffic Law Section 375, 12A, B, 2. A judge of this court granted defendant leave to appeal. 2. Vehicle and Traffic Law Section 375, 12A, B, generally provides that no person shall operate any motor vehicle upon any public highway, road, or street with windows which have a light transmittance of less than 70%. An automobile stop may be lawfully effectuated where law enforcement has probable cause that a driver has committed a traffic violation, see People v. Henshaw. The relevant question for a suppression court in determining whether law enforcement had probable cause is whether the officer who stopped the car reasonably believed the windows to be over-tinted in violation of the Vehicle and Traffic Law, see People v. Estrella, People v. Hicks. When a defendant challenges the sufficiency of the factual predicate for the stop, it is the people's burden to come forward with evidence sufficient to establish that the stop was lawful, People v. Bachman. Summary statements that the police had arrived at a conclusion that sufficient cause existed will not do, People v. Botan. Rather, the prosecution must establish the basis for the belief that law enforcement possessed the requisite suspicion in the form of facts, not assurances. While the review of probable cause determinations typically presents a mixed question of law and fact, when an issue arises as to the standard by which probable cause is measured, the minimum showing necessary to establish probable cause, a question of law is presented for review, People v. McCrae. Such question is presented here. The full extent of Detective Fortunato's testimony regarding the tinted windows was that the windows were excessively tinted. Window tints are not categorically impermissible under New York law. They are only prohibited for specified windows to the extent that they allow less than 70% light transmittance, Vehicle and Traffic Law Section 375, 12A, B. Detective Fortunato's testimony that the tint was excessive is, thus, effectively a legal conclusion that the tint violated the Vehicle and Traffic Law. Yet, the people fail to elicit any factual basis for this conclusion. The detective did not testify, for example, that the windows were so dark that he could not see into the vehicle, see People v. Biggs, People v. Brown, People v. Collins, or that he had training and experience in identifying illegally tinted windows or conducting this type of stop, see People v. Jones, People v. Bequie. Nor did the detective testify that he measured the tint after stopping the vehicle and the results confirmed that the tint level violated the Vehicle and Traffic Law, which could have provided objective, corroborative evidence of the reasonableness of his conclusion, see Estrella, People v. Swift. Without more, the record is bereft of evidence of its basis to support the detective's conclusory belief that the tinted windows violated the law. Consequently, Criminal court should have granted defendant's motion to suppress. Given our holding, we do not reach defendant's remaining arguments. Accordingly, the order of the appellate term should be reversed and the accusatory instrument dismissed. Order reversed and accusatory instrument dismissed. Opinion by Judge Singas. Chief Judge Wilson and Judges Rivera, Garcia, Canataro, Troutman and Halligan concur. Decided May 16, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law